We're going to turn now to the ABC News exclusive tonight after Donald Trump was fined nearly $355 million in his civil fraud case. Tonight, New York State's Attorney General Letitia James saying she's prepared to seize Donald Trump's assets, including his buildings, if he doesn't pay the money. ABC's Aaron Katersky one-on-one tonight with the Attorney General.
4 days after a judge ordered Donald Trump to pay $355 million for a decade of fraud, New York Attorney General Letitia James says she's prepared to do everything she can to make sure the former president pays his fine, including, she told us, seizing the buildings that bear his name.
If he does not have funds to pay off the judgment, then we will seek, judgment enforcement mechanisms in court, and we will ask the judge to seize his assets.
Trump was held liable for exaggerating his wealth and inflating the value of his real estate so banks would give him low-interest loans. Trump insisted the banks liked doing business.
Letitia James told ABC News something specific in the interview that opens this document. If you want something done, give it to a woman. That line has gotten attention as a political statement. What it actually is analytically is a description of institutional posture. James has been methodical throughout the civil fraud enforcement story in a way that most coverage has not fully captured. The March 6, 2024 Westchester County filing and the lien on Seven Springs and Trump National Golf Club that I walked through in a prior commentary happened without announcement, without press conference, just a document filed with a county clerk. Preparation for enforcement before the deadline arrived. The ABC News interview where she said she is prepared to seize assets including buildings if he doesn't pay, no. That interview happened within the documented enforcement period. What James was describing was not a new threat. It was a statement of the next step in a sequence that had already started. I need to be direct about something before going further because this document presents a specific narrative about where the enforcement stands. Accounts frozen, properties being seized, Supreme Court rejecting an April 23, 2026 emergency motion 5-4. And that narrative contradicts what this series has already established. A prior commentary in this series documented the August 2025 Appellate Division ruling. The fraud finding was unanimously upheld by all 5 appellate judges, and the $354 million disgorgement penalty was vacated as constitutionally excessive under the 8th Amendment. The same commentary documented that Trump posted bond through Don Hankey's Knight Insurance Group after the Appellate Division reduced the bond requirement to $175 million in March 2024, and that the enforcement mechanism paused while the appeal proceeded. The compliance monitor remains. The officer bans remain. The lien on Westchester properties remains.
General Letitia James is telling Donald Trump in that clip, in no uncertain terms, pay up. The ex-president is on the hook for roughly $500 million after his civil fraud case, and every day the fine goes unpaid. Trump owes an extra $87,500 in interest. Oof. And in addition to the fraud judgment, Trump still owes writer E. Jean Carroll $83 million for defamation. I asked one of Carroll's attorneys what happens if he doesn't pay.
We can start taking steps to actually enforce the judgment, which means going to the court and asking for an order for us to start attaching assets. I mean, this money has to be paid. And if he's not able to secure a bond or pay the full amount to the court, then we will take steps to make sure that the judgment's enforced.
As A.G. James told ABC News, quote, if you want something done, give it to a woman. And it seems like these women are going to do what is necessary to get Trump to pay for what he...
The April 23, 2026 emergency SCOTUS motion described in this document, 5-4 rejection, accounts frozen, imminent property seizures, I cannot verify as described, and it is in tension with what the series has established about the August 2025 appellate ruling and the bond posting. I will work with what is verified. Subscribe and hit the bell. Leave a like. Because what I want to work through is the pattern of SCOTUS emergency stay rejections this document correctly identifies, what Roberts' repeated votes against Trump reveal about the court's institutional posture, and what the E. Jean Carroll $83 million judgment adds to the enforcement picture that most coverage treats separately from the civil fraud case. That picture is real and significant even without the unverified specifics. The hush money sentencing case in January 2025 is verified. Trump's lawyers asked the Supreme Court to block the sentencing while he appealed. The court said no, 5-4. Roberts joined the liberal justices. The court said the sentencing posed only insubstantial burden to Trump, that he could appeal after sentencing, that there was no reason to intervene early. The Mar-a-Lago special master case from 2022 is verified. Trump wanted the Supreme Court to overrule lower courts and appoint a special master to review classified documents the FBI seized. The court declined to grant certiorari, didn't even take the case, and let the lower court ruling stand. Both of those rejections share a specific character. Trump came to the court seeking emergency intervention, arguing that he should get something that normal litigants do not get: earlier access to the court, intervention before the normal appellate process was exhausted, special treatment because of his political status. Both times the court said, go through the normal process. Both times Roberts was with the majority. That pattern is the institutional signal. Not that Roberts is anti-Trump. That Roberts is an institutionalist who has consistently refused to extend the court's emergency jurisdiction to accommodate arguments that amount to, I should be treated differently because I am Donald Trump. The appointed justices are not loyal justices. That is a distinction the document correctly identifies, and that has been visible across multiple cases. Barrett is a committed originalist. If constitutional text and history don't support a claim, she doesn't support the claim regardless of who appointed her. Roberts cares about the court's institutional reputation. A Supreme Court that routinely grants emergency relief to sitting presidents in civil fraud cases would look like a political institution rather than a judicial one. Roberts is not willing to do that. Trump's true social reaction to court rejections: SCOTUS abandons Patriot, attacking Roberts by name, calling justices who rule against him part of the deep state, is its own analytical data point. It reveals the assumption that produced the disappointment. Trump treated his court appointments as an investment in future protection. The appointments were made expecting a return. When the return doesn't materialize, it's experienced as betrayal rather than as the court doing its job. That assumption was always constitutionally incorrect. Justices take oaths to the Constitution, not to the president who appointed them. Lifetime tenure was specifically designed to insulate their decisions from presidential pressure. Roberts has been making this point through his votes for several years now. The E. Jean Carroll $83 million defamation judgment runs parallel to the civil fraud case and deserves separate treatment. Carroll sued Trump for defamation over statements he made denying her sexual assault allegation and attacking her credibility. A jury found in her favor and assessed $83 million in damages. Carroll's attorney, in the clip from this document, described the same enforcement process James is pursuing: going to court, asking for orders to attach assets, making sure the judgment is paid. Two separate civil judgments. Two separate sets of attorneys pursuing enforcement. Two separate judgments. Roughly $83 million from Carroll, plus whatever the civil fraud penalty recalculation produces following the August 2025 appellate ruling, both sitting on the same defendant. The daily interest the document describes on the civil fraud judgment, $87,500 per day while unpaid, compounds the financial picture. Even if the $354 million disgorgement was vacated and sent back for recalculation, the recalculated figure plus the Carroll judgment plus accumulated interest represents a significant ongoing financial obligation. The compliance monitor is still in the building. Retired federal judge Barbara Jones reviews every significant Trump Organization financial transaction in New York. The officer bans on Eric and Donald Trump Jr. are still running. The lien on the Westchester properties is still registered. The enforcement infrastructure that James built is still in place. What remains uncertain, because the appellate recalculation of the penalty is ongoing, is the specific dollar figure that the infrastructure is working toward. James said she's prepared to do everything she can to make sure the former president pays. What everything means in practice depends on what the recalculated penalty figure is and whether Trump can post bond or pay when that figure is determined. The James interview is from the period before the August 2025 appellate ruling changed the penalty figure. The enforcement posture she described, prepared to seize assets, remains the posture even after the penalty was recalculated, because the fraud finding was not disturbed and some penalty will be imposed. What the specific penalty will be, when it will be final, and what enforcement looks like at that point are the forward-looking questions the accountability record cannot yet answer. What the record can answer: the fraud happened, 5 appellate judges unanimously agreed, the enforcement infrastructure is in place, and James has been consistent about her posture. That is where this story actually is. The Roberts pattern deserves more precise treatment because it is the most analytically significant institutional signal in this document's verified content. Roberts has voted against Trump's emergency stay requests in the hush money sentencing case and in prior emergency applications. The pattern is consistent enough to warrant naming what it represents. Roberts is the Chief Justice. He manages the court's institutional reputation with unusual deliberateness. His votes in high-profile politically charged cases have tracked a consistent principle. The court will not extend emergency jurisdiction to accommodate arguments that are essentially about a litigant's political status. You don't get a stay of sentencing because you're a former president running for office. You don't get special intervention in a civil fraud case because you're the sitting president. The institutional principle Roberts is applying is that the Supreme Court's emergency docket is for legal emergencies, situations where irreparable harm will occur before normal processes can address it, not for political emergencies where a high-profile litigant wants faster access to the court than normal process provides. Trump's emergency applications have consistently been political emergency requests dressed as legal ones. The hush money sentencing created an insubstantial burden, the court's phrase, not an irreparable legal harm. The civil fraud enforcement machinery, even at its most aggressive, does not create the kind of constitutional emergency that warrants SCOTUS intervention ahead of the normal appellate process. Roberts understands that a court that grants emergency relief to sitting presidents in civil fraud cases will look like an extension of the executive branch rather than an independent judicial institution. His vote to deny is, in part, an institutional self-preservation vote. He is protecting the court from appearing to be exactly what Trump's critics claim it is. That is why the rejection pattern matters beyond the individual cases. Roberts is establishing, through consistent votes, that the court's institutional integrity takes precedence over the political interests of the president who reshaped its membership. Whether that precedent holds in future high-stakes cases is the forward-looking question. The Carroll judgment's place in the accountability story is worth spending more time on because it tends to get treated as a separate narrative from the civil fraud case when they are part of the same picture. Carroll sued Trump twice. The first case, the original sexual assault and defamation claims, produced a finding that Trump had sexually abused Carroll and a defamation judgment for statements he made denying it. The second case, additional defamation claims for statements made after the first case was filed, produced the $83.3 million verdict. Together with the civil fraud judgment, whatever figure the recalculated penalty produces, Trump is a civil defendant with multiple 8-figure judgments against him from different proceedings with different juries based on different evidence. The Carroll juries were not Engoron. They were not a judge conducting a bench trial under a specific statute. They were 12 New Yorkers evaluating evidence about what Trump said and whether it was false. They found the statements were false and harmful unanimously. The appellate court that will eventually review the Carroll verdicts is a different court than the one that reviewed the civil fraud case. Different legal theories, different standards, different evidence. But the cumulative picture, 2 Carroll verdicts plus the civil fraud finding, is one defendant, one court system, multiple proceedings, consistent results. Carroll's attorney said the money has to be paid. That is the correct legal description of what judgments are. They are not suggestions. They are obligations that carry enforcement mechanisms. Whether the full Carroll judgment is paid before the civil fraud recalculation is complete, and whether those enforcement processes interact with each other in ways that affect which assets are available, is the logistical question the enforcement teams are working through. Both judgments exist. Both are permanent. Both have attorneys pursuing enforcement. Something I keep coming back to. The bond posting itself is analytically significant in a way the document does not capture because it predates the document's framing. When Trump could not post the original $454 million bond, when 30 insurance companies refused to underwrite it and had to ask the appellate division to reduce the requirement, that process produced its own accountability record. The 30 insurance company refusals are in the record. The bond reduction request is in the record. The Don Henke connection is in the record. The fact that the most prominent real estate developer in the world, claiming a net worth he said publicly exceeded $1 billion, could not find an insurance company willing to underwrite a bond at the value of the fraud judgment against him. That fact is permanently documented in the civil proceedings. The disparity between the claimed net worth and the practical ability to post bond is the civil fraud case's central finding made visible in real time through the enforcement process. You cannot claim to be worth billions and simultaneously be unable to find an insurer for a $500 million bond. The inability to post bond is market confirmation of the gap between the claimed wealth and the actual financial position. That gap was the fraud. The bond crisis made it visible in a different way than the trial did. The appellate division's decision to reduce the bond to $175 million and Trump's ability to post that amount through Don Henke is also in the record. The reduced amount was postable. The original amount was not. The difference between $175 million and $454 million is the distance between what Trump could actually access and what he had publicly claimed to have available. All of that is in the record now. It does not expire when the case resolves. Last thing about where the enforcement story actually stands, because the document's framing, Trump is finished, accounts frozen, properties being seized, no way out, is significantly more dramatic than what the verified record supports. The verified record, the fraud finding stands, unanimously confirmed by 5 appellate judges. The penalty is being recalculated following the August 2025 ruling that the original $354 million disgorgement was constitutionally excessive. The compliance monitor is still in the building. The officer bands still run. The Westchester liens are still registered. That is a significant accountability result. A president of the United States is operating a business under the supervision of a court-appointed monitor subject to loan restrictions, with officer bands on his sons, carrying a fraud finding that 5 appellate judges unanimously upheld. That is not finished. It is constrained, supervised, operating under conditions that would not exist if the fraud had not been found. Whether the recalculated penalty produces a number Trump can pay or a number that requires the enforcement machinery James has built to activate at full scale is the forward-looking question. James said she's prepared to do everything she can. She has demonstrated she means that through the systematic preparation, the Westchester filing, the compliance monitor advocacy, the consistent public statements about enforcement readiness. The accountability infrastructure is built. Whether it fully deploys depends on what the recalculated penalty is and whether Trump can satisfy it. The fraud finding is permanent either way. One more thread worth pulling. The appointed justices are not loyal justices observation and what it means for how the accountability story runs through the court system going forward. Trump's court appointments were understood at the time as a long-term strategic investment. The assumption embedded in that investment was that ideologically aligned justices would interpret the Constitution in ways broadly favorable to conservative executive power claims. That assumption was largely correct for the first several years. The court's shadow docket moved in the administration's direction on immigration enforcement, agency firings, and spending disputes. Where the assumption has failed is in the category of Trump-specific emergency relief. When Trump comes to the court not as a president asserting broad executive power claims, but as a civil defendant seeking to delay enforcement of civil judgments against him personally, the court has consistently said no. That distinction between the court's treatment of executive power claims generally and its treatment of Trump-specific emergency relief requests is the one the accountability story requires being precise about. A court that extends significant deference to executive authority on immigration and agency regulation is not the same court that will grant emergency stays in civil fraud enforcement cases. The former is about the scope of constitutional executive power. The latter is about whether a specific litigant gets special procedural treatment because of who he is. Roberts draws that line clearly. The court's treatment of broad executive power questions is one thing. Giving a civil fraud defendant emergency relief from normal enforcement processes because he is the president is another. Roberts will not do the second even when the court's conservative majority might support broad executive power in the first category. That distinction is the accountability story's clearest institutional signal from the court. Not that the court is aligned against Trump, that it will not extend emergency jurisdiction to shield him from civil enforcement of verified fraud findings. The fraud finding remains. The enforcement infrastructure remains. The compliance monitor remains. James said, if you want something done, give it to a woman.